Allie?
All right, it's Extreme Makeover Criminal Edition. A court is allowing this accused killer to have a makeup artist cover his swastika tattoos, saying that he won't get a fair trial otherwise. John DiTullio is a suspect in a double stabbing that wounded a woman and killed a teenager. The cost to taxpayers, $125 per day. Dr. Douglas Keene is a trial consultant, and Joey Jackson is an attorney and former prosecutor. They join us for a fair and balanced debate. Good morning, gentlemen.
Good morning.
Dr. Keene.
Good morning.
Dr. Keene, let me start with you. So this defendant's attorney believed that seeing swastika tattoos might prejudice the jury. He's probably right about that. Why is it the court's responsibility and therefore the taxpayer's responsibility to protect this defendant from himself?
I think really what we need to think about isn't so much the defendant, but the jurors themselves. What he has done is actually make their very difficult job a little bit easier. Because one of the things that he's going to be instructing them to do is to listen very carefully to the evidence and base all of their opinions and conclusions on the evidence itself. And what we're looking at here is a man whose neck, whose tattoos, are not evidence. They're evidence perhaps of bad taste, they're evidence of who his friends are, but they're not evidence of whether or not he actually committed a crime. And by obliterating or obscuring some of those tattoos, what the judge has said is, jurors, breathe easy. You're actually not going to be distracted from the evidence in the case. You're going to be able to judge it based upon what's actually evidence and testimony from the witness stand.
Mr. Jackson, your response to that?
Well, here's the response. First of all, I think citizens should be afforded at least as much rights as criminals are afforded. And speaking of rights, I think jurors have a right to be leveled with. Jurors have a right not to be misguided. The fact is this. I believe that the jury system lends itself to being open and being logical. There are so many other alternatives to this that could satisfy the jury. Number one, what can you do? During jury selection, you can voir dire them on it. You can talk to them and say, look, none of you will hold this against my client, will you? We understand people have tattoos for various reasons. We have debates. All of us have personal opinions. It doesn't mean he did this crime, does it? Just means he has this philosophical view. Number two, a judge can give a curative instruction. What does that mean? They can say to the jury, ladies and gentlemen, you cannot use this in any way, shape, or form. It is not evidence. And finally, if the defendant testified, he can explain himself his basis for having these tattoos. This misleads the jury. Misleading is not good. We need to be open and honest and fair. This is not the way to do it.
Very quickly, Dr. Keene, those are all three great suggestions. Why are you shaking your head no?
The problem is that there is no way to erase bias. What jurors will say is, Your Honor, I will do my level best to be honest and to follow the rules that the court sets forward, but there is a huge body of research that's been collected over decades now that biases and prejudices and fears simply do not get set aside just because a judge gives a curative instruction. It doesn't work that way. Human nature doesn't work that way.
The point is that we select juries all the time, and in selecting them, it is our job to determine who is fair, who is reasonable. I believe this was a voluntary choice. Putting a tattoo is a voluntary choice. Taxpayers should not have to pay for that. This is something he did. He should live with it. We should not be misguiding our jurors.
Dr. Douglas Keene, Mr. Joey Jackson, thanks so much for coming in for this really interesting debate. We appreciate it.
Thank you.
All right, the president's own